Yes, Mr. Bhattacharya.
Two appeals have come up for my lord's kind consideration.
Yes.
Now,
My learned friend Star Malord Medal, on the last occasion I have given a judgment which should be in the record that whether an order of amendment can be given retrospective effect if it is a clarificatory in nature. That is,
Can be given that.
yes. So, my lord, that is the thing. In my case, that has been given effect, and this division bench of Justice Dash has also
Held that proposition.
has also affirmed that.
Lord, I tell your lordship, my lord, so far the matter is concerned, I found, my lord, that the proposition of law which is involved is as to whether any particular, my lord, notification or order can be given retrospective effect. Now, I find from the judgments, I have brought also the judgments which my lords have laid down the law, that certainly it can be given if there is a provision in the statutory provision of giving the retrospective effect. But if not, the same cannot be given, it will always be prospective. Now, this is the point.
That is with regard to delegated legislation, subordinate
Yes, of course, I'm grateful to my lords. I'm
with
grateful.
regard to subordinate legislation, the retrospectivity would depend whether the primary legislation
Has
resolves
been
the
given
right.
or not. I'm grateful to my land.
Resolves the right.
I have all brought the authorities, my lord. I need
The
not.
problem, Mr. Bhattacharya, a coordinate bench is taking a
My lord, that is the thing, my lord, which is coming for my lord's kind consideration. This is number one. Number two, my lord, it appears, my lord, when the matter was taken up, my lord, kindly see the last order, my lord, which was passed by the honorable division bench when this matter was taken up. My lord, their lordships, my lord, were pleased to pass a direction, my lord, to directing the state to file a report showing the particular, my lord, the notifications and or orders prevailing in the field. Kindly say my lord's orders, my lord, on the last time.
One thing more, my lords, before you, Mr. Bhattacharya. Whether what when he is not a contesting candidate, whether he can maintain the appeal.
no.
Lord, I don't.
He is not a contesting candidate. He has admitted, my lord.
Then, Mr. Bhattacharya, did you apply for this post?
My lord, I submit to my lord.
Are you were you an applicant for the post where Mr. Agarwal's
My lord, these are the
predecessor?
I am telling your lordships, my lord.
Consistency.
My lord, kindly consider, my lord, this I am to show before my lords, my lord. Kindly see one provision, my lord, the engagement on compassionate ground, and my lord, rule 7. My lord, kindly, and there is, my lord, kindly excuse me, I have given a, my lord, this is the thing, my lord, and I also submit, my lord, very respectfully before my lords, that, my lord, your lordship may kindly consider.
One second.
Yes, I'm sorry, my lord, I'm sorry. 26/7.
26 the distributor.
No. 20.
20.
I'm saying 26.
20 at 6. No? This one.
20 sub.
May I give another copy, my lord? I have got this copy.
Two copies, yes. I have given the bottom, the particular date.
ওইখানে দেখেছো তোমায় আমি কি বলছি, এইখানে আমার বইগুলো রাখো তো, এই এসেনশিয়াল কমোডিটিস অ্যাক্ট, আর যেদিন গ্রুপ 7 থাকবে, এই গ্রুপ 5 থাকবে, সব ওই কেএমসি ওয়েস্ট বেঙ্গল এইখানে সব ওইখানে বার করবে, এয়ার অ্যাক্টস গুলো এখানে থাকবে। Yes, what are you saying?
I am submitting very respectfully, Miller. Kindly see the bottom, Miller. I have given a red tick mark, Miller, in my book. I have the.
You have no book.
I have given the book. My book I have given.
What will you read from? You read whatever you want to read. Yes.
Kindly see 26/7. When an individual licensee opt to convert his business into partnership firm for the reasons of his physical incapacitation, or a licensee of a partnership firm opt to induct a new partner or substitute the name of an existing partner, the licensing authorities may, on an application in Form C3 along with the Annexure 1, requisite fee as prescribed in Schedule A and corroborative documents as per checklist made by the licensee in this behalf, allow him to do so on examination of the inquiry report in Form L2 and comments of the SCF and S in Form number M2 with the approval of the director, if and only if any of the family members of the licensee having no regular means of income is inducted or substituted at partners or otherwise. Then Miller, kindly see this particular provision under 7, there is an italicized word, my lord, 1, and my lords may kindly come to the bottom, subclause 7 substituted by clause 3E of the notification number 3034 FS section F, food dated 14 December 2020. Has my lord got it, my lord? And this is in respect of 1. Now, my lord, I am to show before my lords that the learned single judge, my lord, proceeds as if, my lord, this particular operation of this particular provision was given in a retrospective manner. There, what was the law, my lord, which was prevailing, that also I have brought. My lord, kindly see, this is a government notification.
What is your scope of challenge?
My scope of challenge is we are the family members. We are the family members. On an earlier occasion, a learned single judge passed an order to make an inquiry and to pass an order. Then, my lord, there was, my lord, the subdivisional officer passed 2 independent orders.
Were you a partner in that?
Yes, we were. My lord, Mr. Agarwalla, my lord, I can show from the records. I cannot say anything more. My lord, I am just showing to partner. I am not saying a partner. I am saying a
What
party.
is your interest in that?
Because I say, my lord, I want to contest. I want to get a particular MR dealership, and he says that you are not because we have formed a partnership firm.
But then the MR dealership, the vacancy has not been declared.
My lord, I submit, my lord, kindly for a second, my lord, your lordship may kindly, my lord, I permit me, my lord, to place the earlier order and the 2 things. I just, I have nothing more to submit. My lord, kindly see this particular order, page 53 to 56 of this particular stay application. There are 2 appeals, my lord, আমি দাদা নিয়েছি ওই 119.
You had applied for transfer.
My
You
lord,
are the writ petitioner, right?
my lord, here Vishwanath, I am appearing on behalf of Vishwanath Ghosh. Not Vishwanath Ghosh, the legal heirs of Vishwanath Ghosh.
Correct. In the
The
page
Jogmaya Ghosh and others.
you are for Jogmaya Ghosh.
Yeah, Jogmaya Ghosh, Subroto Ghosh, Suman Ghosh, and Topon Ghosh. ঠিক আমি page 53. এই দুটো অর্ডার ছিল এসডিও, দুটোর অর্ডার দেখাতে, একটা তো এখানে আছে ওইটাতে, আরেকটার অর্ডারের পেজটা বলো। আমার কথাটা বুঝেছিস? একটাই হচ্ছে, হ্যাঁ এইটাই চেয়েছি, একটা হচ্ছে এটা।
আপনি দেখাচ্ছেন সেটা
দাঁড়া, দেখি এইটা কত পাতা, পেজ 98। 1 মিনিট।
অন্য
সেটাই তো ইয়ে করেছে। এটা একটা, আরেকটা অর্ডার কোথায়? এটা কোন অ্যাপিলে? সেকেন্ড, বাস, ঠিক আছে, ঠিক আছে, ঠিক আছে, এইটাকে না থাক, ঠিক আছে।
Are you claiming through Utpal? Are you claiming through Utpal?
No, man.
No.
I am appealing for it.
He is appearing for Utpal. My line friend is appearing on behalf of.
You are appearing for Utpal. Who are appearing for
Vishwanath, my learned friend, is appearing.
the
My lord, in fact, there was a partnership between Ajay Ghosh and Utpal Ghosh.
My lord, I submit to my lords, my lord, that these partners.
Vishwanath and Tapan?
Vishwanath Tapan, my learned friend, is appearing, my lord.
Correct. So they appear. Vishwanath and Tapan made an application
Yeah.
for transfer of dealership in their names on
I told you,
compassionate
lords,
ground.
I'm grateful to my lord.
Now,
I also,
so the learned single judge says that Utpal can also ask for
because I was also applicant there.
also a heir.
I was also an applicant therein.
And the subdivisional officer passed two independent orders in the matters connected. One order, my lords, will be pleased to find from page 74, 75.
My lord, until,
Well, listen,
Come later on.
I'm
First,
sorry,
lay down
Mr.
facts.
may I tell your lordship the facts?
I'm sorry.
There was a
First, listen, Mr. Agarwal, the facts that we have followed is Jogendro was the dealer. Jogendro died. Jogendro had 4 sons. Now,
no, my lord, not Jogendra. My lord, Ajay and Utpal, they were the dealers.
originally
His father was dealer who transferred his dealership.
One second. Originally, Jogendro was the dealer. He had
Yes.
4 sons. Now, dealers on his death, Ajoy and Utpal formed a partnership firm and the dealership was in their name.
Yes.
Ajoy dies.
Right.
Ajoy does not have any children.
No.
Now, Vishwanath and Topod make application for transfer
Dealership in their favor.
in their favor on compassionate ground. Huge,
I also claim.
the application is rejected because it is said that they were not the only heirs. Utpal was also there. So learned single judge says
The both
that-
were applicable. Make
that-
individual application.
both Vishwanath as well as Utpal can apply and it shall be decided in terms of subclause 7 of paragraph 20 of 2000.
Yes. Now, my lord, kindly see paragraph 7.
Now this paragraph 7 of subclause 7, now you are resurrecting the issue that it will not apply.
No, I'm not, kindly consider, my lord, I submit to my lords, my lord, that's a thing, my lord, I very respect, this is a particular, my lord, a misinterpretation of
So
the,
you are saying that it,
I'm saying that it will come into effect from the date it has been published in the notification. That's all I say.
that when the order was passed,
My lord, this order, my lord, subject to correction, this was
according
passed on
to- Mr.
13 to,
we
sorry,
understand.
I'm sorry, my lord.
According to you, what was the pre-amended clause 7?
That's the thing, my lord, I brought this.
Apply.
Yes, that was the
The
thing.
amended 7 will apply
That,
because the direction
that was my submission.
for consideration is in 2018 when the clause was not in force.
My lord, this is the pre-amended, my lord, this is the government copy, my lord, I have brought it for my lord's.
My lord, before it, your lordship, kindly see who is the family member, they can apply only. Other than family, legal heirs cannot apply. Only family members who are defined in the control order can apply. That is at paragraph 2M in the control order. And family members, my lord, that is spouse or parents or son.
Brothers,
No. Widow of predeceased son and daughter. So, partnership was formed between 2 brothers. One brother died, second brother remains. My client remains. Now, my lord, there was a vague whether I can be given license or not when there is no other family member for getting this appointment. Then this clause was amended by way of a clarification, and that was given in retrospective. That the court had directed to give retrospective effect.
The problem is, if this amended clause does not apply, then your partnership form extinguishes.
Yes,
Your partnership form extinguishes,
yes.
and you cannot be appointed.
But if amended clause, as I have given the judgment, my lord, that it was by way of clarification, that the remaining partner may apply individually. That is, your lordship find at 7.
Judgment.
How can that be clarification, Mr.? It's a fresh right created.
No, that is clarification, my lord. There was a vacuum. What will apply?
Vacuum is not a clarification. What is vacuum?
When there is a vacuum,
Let us see what is.
Yes.
But then
Correct.
to decide that,
well, kindly see the judgment. If there is a gap in the clause, it has bridged the gap. By making this amendment, the gap has been bridged by the authority, by the statute. And that has been, my lord, held by this division bench of this honorable court, citing so many judgments of Supreme Court.
but Mr. Bhattacharya, you
Yes,
by
sir.
yourself, you did not have a right to apply.
My lord, I submit to my lords, my lord.
That is so. How can you?
My lord,
challenge-
I submit to my lords, my lord, subject to kind sanction of my lords, that my lord is right.
Let us, for argument's sake, can a stranger
Yes.
challenge this order of compassionate appointment,
No.
saying that
I say, my lord, if your lords,
so you are a stranger to
my lord, I say, my lord,
Right.
here I join an issue. I say, my lord, I submit to my lords, my lord, your lordship may kindly consider the particular judgment which was referred to by the learned single judge. Kindly consider that judgment. What was the contextual situation and vis-a-vis what is the case in my case? What is the matter, my lord, which has come up for my lord's kind
No,
of
understand.
My lord, I say, my lord,
Don't
kindly
allow
consider.
me to-
And I submit, my lord, kindly take note of it.
Family nahi.
My lord, kindly take.
If Partha's order is implemented, he is otherwise not entitled.
My lord, I submit to my lords, my lord, if your lordship
Starting from 1964, your lordship knows, my lord, the person who has no right.
This is the only thing, my lord, your lordship may kindly, my lord, my lord, kindly see this and my lord, I say, my lord, whatever my lords, my lord, wants, my lord, kindly see, my lord, I say, my lord, this is 2008, volume 13 SCC, 213, paragraph 36. দুটো করে দিস Millard, this is 2008. I'm sorry, Millard. This is the one Millard which I have two judgments. 2008, volume 13 SCC, 213, paragraph 36.
Paragraph 36.
Retrospectively accepted. Fine. First, cross the door that you have a legal right to challenge this.
Millard, I say, Millard, kindly consider this thing that whether I am just showing. I তোকে যেটা ইয়ে দিয়েছিল যে একটা লাইসেন্স দিয়েছিল না? Miller, kindly consider the situation when the partnership stood dissolved. When the partnership stood dissolved, we stand in the same footing.
No,
Then Miller,
you stand in the same footing as the third party on the road.
Miller, I submit to my lord that
Sit
whether
down.
I have a genital relation or a particular blood
And
relation.
genital will be seen later on. You are not within the definition of family. Simple.
Aggrieved party, my lord. That is
Appellant has assailed.
Miller, kindly take into consideration the Miller. I submit to my lord's Miller. Your lordship may kindly consider the definition of family. Definition of family.
Where-
I learned-
Appellant has assailed judgment and order dated so and so.
This will have a Miller. I submit to my lord's Miller that a particular provision is being made to operate retrospectively.
Very good.
December 2023.
14 December 2023, whereby by writ petition, you had also said?
Yes, I was also writ petition therein because my one claim was also rejected by the controller. So that was allowed, that writ petition was allowed, and his writ petition was dismissed. Both were heard analogously.
Milord, one thing I'm being, Milord, submitted by the bar, Milord, kindly excuse me. From this, I should, Milord, I'm grateful to my learned junior, Milord. From February 24, 2024, there has been a particular amended definition of family, Milord, which I am handing over to my lords. এটাই তো? This I am just, Milord,
But
drawing-
Mr. A, let's look. Your prayer was also turned down.
No,
Yes.
yes, by the controller.
That's what we are saying.
both turned down.
Both were turned down.
Yes, but then that will not apply because it's in 24.
24. Why I am showing, Milord? This has there has been an amendment of
Correct, but the decision was taken.
This
Writ petition,
decision was not
writ
taken
petition-
based on this particular order.
writ petition was disposed of when?
December 2023.
December
2023.
23.
After that, that's the reason. But this is I can show, I'm just bringing it to the notice of the court. I
That
cannot show.
argument, you can argue always that if retrospectivity to Mr. Agarwal, then retrospectivity to
He
you.
was-
But Mr. Agarwal, the issue of retrospectivity will squarely come in your case. The issue of retrospectivity will squarely come in your case. Because Mr. Bhattacharya, we understand the reasoning given by
He
the
is not
learned
agreeing
single
party.
judge is
He's
holds
not an
water,
agreed party
holds
to that
water.
extent. Yes.
that he was not a family member, could not have compassion for her. So far as your case is concerned, you are seeking relief with regard to applicability of an amended clause.
My lord.
And there Mr. Bhattacharya says that this relief should not be granted because of this part, this argument. Now,
But
that-
my argument is, my lord, that is because of the fact that if there is any amendment, that cannot be given retrospective effect until there is a specific direction in the statute. But my case is that when there is a gap, and that is bridged by way of clarificatory
it's a gap.
gap was, my lord, that if there is a compassionate appointment,
Right. So everywhere you must have a compassionate amendment.
but compassion is there, already compassion is there.
Let's say a person who was a licensee, was a bachelor, did not have any member family.
So he
Till then, let someone says that I helped him for his medical purposes. So please.
no, my lord,
take
not I'm not on that. But the person who was already an existing dealer along with him,
over.
then, my lord, what will be his fate? That was a gap.
He will go.
No, that was a gap. So when a compassion is given, your lordship kindly see paragraph 20, paragraph 6. What is the compassion? He is a surviving partner. And that's why the clause has been amended by way of clarification. Can come to page 1.22b.
Show us the clause again.
1.22, page number 1.22 at top. And clause B.
2013 control
My
order,
lord, this is
26
20,
or 20.
clause 20.
My lord, your lordship will,
Page
your lordship will
7.
get a tick mark in my book. I will.
6 was page
One of the part of the suburban.
P.
Huh?
In case of death of a partner, has your lordship got, my lord? A partner here having the dealer license, if no eligible family member found to become the partner or partners, as the case may be of the said partner, the last surviving partner may apply for the conversion before the licensing authority, and upon satisfaction of licensing authority, the said surviving partner will be allowed to continue. So, my lord, this was a gap which has been included in the compassionate appointment. That has been dealt with by the division bench of this honorable court. That where they will go. In paragraph 9, there was a case, my lord, the widow of a son applied upon his demise. Paragraph 9, you will also find in that judgment.
সময় করবো কি সময়টা বের করে দেবো
Have you gone through this judgment?
Yes, I have given him copy that. Yes. I'm teaching him the judgment copy that.
No, just 1 second. কি নাম
Yes.
এটা
I had already supplied.
Yes, yes. I have seen it. I've seen it.
So the broad base and practical amendment, how can it become clarificatory?
My lord, I tell you, sir. First of all,
Clarificatory amendment is where there is a casus omissus. That is a clarificatory amendment.
when there is a confession, my lord,
When there is a patent error, inconsistency, then only a clarification necessary.
my lord, that is the there. Clause 20, paragraph subparagraph 6, my lord, that says that license to be given on compassionate appointment should be given for immediate relief to the surviving members. Here in the partnership, one member dies without having any family member. The another member is the surviving member.
That,
So when there was a vacuum,
that definition of surviving member has been expanded.
Yes.
That definition of surviving member has been expanded. Isn't it, Mr. Agarwal?
Yes, Milord, I have.
Well,
No, I am
that
sure.
is there. That's why that 7, I have shown the clause that 7B, that has been included. That's why. So that he can also survive.
You see paragraph 8.
7B, my lord.
Paragraph 8 of the judgment.
Like the 8 of the judgment. Yes. Clause 2M has undergone change after amendment, Video Gazette, notification such and such. Cursory reading of the entire provision relating to definition of family in clause 2M, along with subclause 6. My lord, that is 6 of clause 20 is the compassionate appointment. So where is there is a compassion and there is a vacuum, that has been clarified, my lord, by paragraph 7B in the control order.
Would you be kind enough to read paragraph 8?
Yes.
8 of the judgment.
Provision of compassion appointment.
8 of the judgment.
My lord, yes. It is clear that provision of compassion engagement to a particular class of persons.
8 of the judgment that you are citing.
Yes, my lord, I am reading that. I am reading.
Justice Dash's
Yes,
judgment.
Justice Dash is a
Paragraph 8, clause 2M has undergone change.
change.
Yes.
So that is what we are asking you to read. Would you kindly read that?
Yes, I am reading that, my lord.
Please read.
Clause 2M has undergone change after amendment with a Gazette notification dated 13 December 2022. In subclause 4 of clause 2M, the words widow of predeceased son has been substituted by son's spouse. Well, that is in the book there was no such amendment. Cursory reading of the entire provision relating to definition of family in clause 2M along with subclause 6 of clause 20 of 2013 order. Well, this clause 6 of 2013 order is the compassionate appointment.
Absolutely.
It is clear that provision of compassionate appointment engagement as MR dealer to a particular class of person as defined in clause 2M is available from the date of coming into force of the 2013 control order. The substitution of widow of predeceased son in subclause IV of clause 2M by the word son's spouse is only a clarification to overcome a situation that we have fixed in the present case. So, my lord, there was predeceased son, now it was about son's spouse. That was amended.
Right.
Yes. Now, my lord, that was also amendment because of the fact.
The amendment is not clarificatory.
But that,
This particular amendment was clarificatory.
like this, my lord, when because it was a vacuum,
There was no vacuum.
there was vacuum. Like, kindly see my lord in the book. That is the widow of the predeceased son.
Correct.
So, what will happen of the son if a son who will die after the demise of the dealer? That was a vacuum, and that vacuum has been.
What is the vacuum? Widow of predeceased son was substituted by son's spouse.
So earlier only widow of the predeceased son was entitled to.
Now it's
Now son's spouse also entitled to.
being son's spouse is also entitled.
Why?
Yes.
Why it was given? My lord, I ask myself, because the son's spouse, after the demise of the original dealer, The son dies after some months, then what will happen of the spouse? That's why this amendment was brought, so that she can also survive. And that was a clarificatory in nature that has been held by this honorable court. And here also, when what will happen of a surviving partner if one partner dies without having family member, so that gap has been bridged by this amendment in B, and that is also clarificatory in nature. Seven B, that has been inserted for this purpose. Legislature in its wisdom has felt about the compassion of the surviving partner, my lord. And in any case, my lord, your lordship will not take me amiss. Whether that issue can be decided in an appeal filed by learned friend who has no locus to file this appeal.
You have filed an appeal also.
No, I have not filed appeal. I have not filed appeal. He has filed appeal. I have not filed appeal. He is not an aggrieved party. Can he file an appeal? Starting from 1964, your lordship knows. Up to, I have brought the judgments also, if your lordship might so desire, that what is the definition of aggrieved party? 2013-4 has my lord clarified who is the aggrieved party. May I give, your lordship knows, my lord, but still, if your lordship wants, I may give that. And moreover, my lord, kindly see one more thing. Vishwanath Ghosh, who made application, he died. And there is no other application. The appeal is maintainable or not, I do not know, my lord. Because Vishwanath Ghosh died. The heirs substituted. Whether they can maintain that application which was filed by Vishwanath Ghosh or which was rejected. And kindly see the cost title of this appeal. It is in the name of Vishwanath Ghosh, reprinted by the legal heirs. In name of a dead person, this appeal has been filed.
Take them.
Well, one thing,
Order whereby the prayer appellants being the heirs and legal heirs and successors of the writ petitioner since deceased in WPA 9. Oh, the heirs and successors have filed the writ petition.
yes,
Heirs and successors.
My lord, they are
the initial, before,
Vishwanath Ghosh was the brother.
That is why Jogmaya and others have filed.
Jogmaya is wife of
Correct. So
right,
petition appellant.
substituted,
substituted by the
No, the writ petition was filed
substituted.
by the heirs and successors.
Yes, that was substituted. Yes. Vishwanath Ghosh filed writ petition, substitution was made, Jogmaya Ghosh substituted in that.
Appellants being the heirs and successors of one Vishwanath Ghosh, bracketed, writ petitioner in WPA 7969 of 2019 has assailed judgment order dated so and so past, whereby the prayer for compassionate appointment of Vishwanath Ghosh to the dealership was turned down, full stop, by the self-same order, and by the self-same order, the prayer for compassionate appointment of
Utpal Ghosh.
Utpal Ghosh, bracket a surviving partner in the dealership, was allowed. One, Jogendranath Ghosh, since deceased, was the original dealer was the original MR dealer and kerosene was the original dealer in MR was the original dealer under English Bazar block in Malda district. Jogendro died intestate, leaving behind four sons, namely Utpal Ajoy Ghosh, Utpal Ghosh, Vishwanath Ghosh, and Tapon Ghosh. Upon Jogendro's death, Utpal and Ajoy constituted a partnership firm, and the dealership was transferred in the name of the firm. Full stop. In October 2015, Ajoy Ghosh died. Full stop. Thereafter, Vishwanath Ghosh and his brother Tapon Ghosh, bracketed, who were uh, Tapon Ghosh, applied for transfer of the partnership, applied for transfer of the dealership in their name on compassionate ground. Their application being turned down, they approached this court in WPA 26937W of 2017 by order dated 21/6/2015. A learned single judge of this court, inter alia, observed Ajoy Ghosh, a bachelor, had died intestate. The surviving partner had also applied for dealership along with surviving partner, that is Utpal Ghosh, had applied for dealership along with your wife, Utpal's wife,
No, no, no. Utpal not.
that is had
Yes,
applied
yes. Initially, my lord, initially.
had also applied for dealership as legal heir of Ajoy Ghosh. Full stop. In light of under such circumstances, learned judge directed the authorities concerned to consider the prayer of Vishwanath Ghosh, Vishwanath Ghosh, as well as Utpal Ghosh, for compassionate appointment in terms of clause 7 of paragraph 20 of the 2013 control order. Learned judge observed that Under such circumstances, the learned judge observed that the applications of Vishwanath Ghosh and his brother Ajoy Ghosh on one, or Taposh Ghosh on one hand, and that of Utpal Ghosh may be considered uh, under such circumstances, the learned judge observed that that the brothers, that is Vishwanath Ghosh, Utpal Ghosh, and Tapun Ghosh may join together as a commercially recognized body and jointly, and their application may be considered in terms of clause 7 of paragraph 20 of 2013,
There it is
Sir?
clause 6.
6 minutes.
clause 6 of paragraph 8, and in the event they fail to join hands, their applications to be considered individual. Pursuant to this direction, the respondent authorities turned down the prayer, both the prayers for compassionate appointment of Vishwanath Ghosh and Vishwanath Ghosh,
And Tapan Ghosh.
Vishwanath Ghosh and Taposh Ghosh, as well as Utpal Ghosh. Both of them challenged their respective, both of them filed separate writ petitions, which were heard together, heard and disposed of by the impugned judgment. Mr. Bhattacharya, for the heirs and successors of Vishwanath Ghosh, submit, for the appellants, submit his client, submit his client did not his client was unfairly, his client's case for compassionate appointment was unfairly submit case of compassionate appointment of Utpal Ghosh was unfairly considered by referring to with reference to the amended provision
Yes.
of paragraph Roman 7 of clause 6 of paragraph 20.
Paragraph 7 of clause 20. 7b.
Paragraph Roman 7b of clause 20 of the 2013 control order. Prior control order did not give option to the surviving heir, surviving partner to make application for compassionate appointment. Accordingly, he prayed that the appeal may be allowed. Good stuff. Mr. Agarwalla, for respondent Utpal Ghosh, raises a preliminary objection. He contends the appellants were not parties. Were they parties in your writ petition?
Yes.
Yes.
The appellants do not fall within the
Family member.
definition family under section
2m.
It's there in the judgment.
Clause 2m of
Definition family member under clause 2m of the 2013 control order.
And which was being subsequently extended, the definition of two. Yes.
2013 control order. As per the said control order, brothers of the family members, brothers of the deceased partner, do not have, are not entitled to pray for compassionate appointment. Good stuff. On the other hand, hence, the appellant did not have legal right to assail, legal right to challenge the grant of compassionate appointment in favor of
Utpal.
the surviving partner, that is Utpal Ghosh. In rebuttal, Mr. Bhattacharya contends that the definition family member was amended in 2024, in February 2024, to 2024 to include brothers of the
Deceased dealer.
heir. Full stop. He submits that brothers of the deceased heir. Full stop. We have considered the rival submissions of the parties. Full stop. The deceased, the Ajoy Ghosh, erstwhile partner to the firm, had died in 2015. At that time, died in 2015. He, at that time, the applicant had died in 2015. Stop. Thereafter, his brothers Vishwanath Ghosh and Taposh Ghosh, Tapan Ghosh applied for transfer of dealership on compassionate ground. The expression compassionate ground, which came to be rejected. In 2018, a learned single judge, in the meantime, Utpal Ghosh, along with his wife, prayed for transfer of dealership.
Well, not in the way, simultaneously. I also made
Utpal Ghosh
also
made application for transfer of dealership on compassionate ground. Stop. In view both their prayers being turned down, the matter was remanded for fresh consideration, either on a joint application if the parties combine together, or in individual capacity. Pursuant thereto by order dated 2018.
two orders, my lord. Two separate orders.
By orders dated, please give the dates.
One is, my lord, 13 March 2019 and another 12 March 2019.
By two several orders, their prayers were turned down. Full stop. They filed separate writ petitions. Full stop. Writ petition, prayer of the appellant was turned down. Prayer for compassionate transfer of dealership on compassionate appointment of the appellant was turned down on the ground the definition family member as operating in the field did not but then this should be given retrospective effect, isn't it?
My lord, then he cannot maintain a writ petition.
He is taking a stand of approbation, reprobation. In one way, they saying
In your division bench judgment, it has
that's
been
the thing.
said that if son's wife is included, then it should be given retrospective.
That's right. He wants a favor he should be given a favor to the extent that particular his rights are covered. The other excluded. That's the thing is approbation and reprobation.
But in appeal, the order under challenge of 23
So what?
So my, in 20,
Continuation.
Today,
of proceeding.
the proceeding is pending.
proceeding is pending, but where, if he has any right to maintain appeal, then only that can be considered.
His right immediately arrives if the clarificatory amendment of 2024 is applied.
But at the time filing this appeal,
Does not matter.
as well also, but I am,
According to your clarificatory amendment,
my lord,
how do you sustain a clarificatory amendment? If you are surviving
Well,
on a
let-
clarificatory amendment,
I have, my lord, taken the
how do you
plea,
sustain this?
I have taken the plea, but my learned friend has not taken a ground in the appeal.
He will take a ground if necessary.
Your lordship can always say so, but my lord, my humble submission, his appeal is not maintainable.
And this judgment does not apply to the
That's the
surviving.
thing I told my lords. I told my lord.
Surviving, my lord.
I say, my lord,
This
with the
judgment does
greatest
not
of
apply.
respect,
Does this judgment apply to a surviving partner?
My lord, that is specific. The ratio is.
Oh,
What is the ratio? In any case, my lord, he is not an agreed party. My first point is that his appeal is not maintainable. And whether can my appointment or this order can be challenged by a party who is not an agreed party
right.
legally.
But
There was
just
no
because
enforceable
the
right.
judge held that a son's spouse is clarificatory, then everything becomes clarificatory in law.
Wherever there is my lord lacuna, that will be
Wherever there will be lacuna, it will be clarificatory. Brilliant.
My lord,
Brilliant.
I can't make any observation, my lord, on the judgment passed by.
No, we are not saying observation on the judgment, Mr.
I have also not said that.
The judgment is to be read in the factual matrix.
Right.
What happens? What was the amendment? A predeceased son's wife had the right. The amendment was son's wife. So they fell in the same species. And that is why the amendment was held to be clarificatory of the same category and species in relation to the deceased licensee, namely daughter-in-law. So whether the daughter-in-law's husband was alive or dead was of little consequence. What was of consequence is the daughter-in-law fully dependent on the
Yes, here also,
licensee.
my lord, that is same thing. I am coming on that. The ratio is that whether I am dependent on that dealership.
No, sir. A surviving partner is a alive and kicking commercial personality.
No, my lord,
Does
this is
not
this is-
equate himself on a daughter.
surviving part. Amendment to
Mr. Agarwal, let us consider this issue further.
my lord, only one thing, my lord.
Draft করে রেখে দাও।
To that extent only, that whether this issue can be just
Mr. Agarwal,
can be adjudicated in an appeal,
oh, yeah, absolutely. Every issue can be adjudicated in an appeal.
which is not maintainable.
If it becomes maintainable as per your argument of clarificatory amendments, filling up lacuna in legislation, brothers are also included.
No, that was in after the judgment is passed.
So these were when Mr. Agarwal, the first judgment for consideration is in 18. When the consideration takes place by the concerned respondent in 18, you are out of court. Then during the pendency of a writ petition is not a continuation of a decision-making process by an administrative officer. So if that interregnum makes an amendment and you are going to take advantage of that amendment, why can't you take an advantage pending appeal? What is the big difference? The basic crux of the matter
Two things.
where we feel you need to clarify
Two
it.
things, my lord. One,
Please, sir, listen to us. The basic thing that you need to clarify is, does Justice Das's judgment with regard to a particular amendment and holding it to be clarificatory makes all amendments
not all
clarificatory?
amendment, not all amendment, my lord.
Why?
But it is the part of
Why does Justice Das's bench hold it is clarificatory? See the reasoning. Their lordships hold that the daughter-in-law is falling in the same genus in relation to the licensee. And since one category of daughter-in-law was already there, it was merely clarified that it will not be a widow of a predeceased son, but son's spouse. That is why their lordships felt this is clarificatory.
my lord.
Now, an additional right given to a surviving partner, can it be held to be
Yes, but
clarificatory
only,
or a new right?
but only one submission in this regard, my lord. It comes under the paragraph 6 of 20. That is compassionate appointment.
So,
Who will be given? Compassion is given to the family members.
well, we need not first and foremost understand the idea of compassionate appointment. It should be strictly construed
Yes.
and not liberally construed as if largesse is being given, which is to be inherited by everyone.
Not inheritance, my lord. That's
So
why
it
the statute
must
provides.
be a strict interpretation of the scheme under the statute.
My lord.
And if this look at compassionate appointment principles in service law, the law, if there is a change of policy, the time when the application is being considered is the time when the policy will apply.
Yes.
In 2018, the policy which is applied is divorce the surviving spouse. So please bring those judgments
I
of
will,
compassionate
I will,
appointment
I
with
will,
regard
I
to
will.
service.
I will, sir. I will.
Those are there, my lord. That if there is any
And
application,
on that premise, we will distinguish judgment here.
my lord, I have made my submission only on the first ground that his appeal is not maintainable. And if the appeal is not maintainable, whether can any other adjudication can be made in this appeal, my lord. First of all, my lord.
You have
That's
been-
why I have given in 1964, your lordship, that all judgments have been referred in.
Mr. Agarwal, we would have agreed with you. We do not wish to give you a cakewalk on an presumably incorrect interpretation of retrospectivity in respect of your amendment and non-suit him by saying that his amendment is not
I do not get, he also does not get.
Absolutely.
That is, my lord, as an officer of the court, I should address to this court. If I do not get, he also does not get it. He wants, I should be given. To him,
It
excluded.
is admitted that he is not getting. Then he will snatch the bread from my mouth also. That is,
No, no.
that is,
No, no, no.
that is, that is, what is an agreed party?
The brain,
If he is an agreed party, then he can maintain an appeal. Suppose, my lord, there is a order of transfer.
Mr. Agarwal, we would have agreed with your aggrieved party argument had you not made him a party in the writ petition. He is a party in the writ petition.
You are the,
Yes,
yes,
so
you
we
are,
asked you, was he a party in the writ
Yes,
petition?
because
Yes.
both were heard.
He is entitled to
Both
appeal.
were heard.
He is
That's why the-
entitled to appeal. He is entitled to appeal against that order. So he has appealed against that order. Why should we non-suit him?
But admittedly, he has been made party. That's why,
We've heard you long.
anyway, my lord, yeah.
Again, we'll hear you again on another day.
Okay.
Maybe you will have better arguments too.
I'm good.
I have, my lord, concluded my arguments. I do not need any argument. If I leave to your lordship, whatever lordship feels, my lord. Which since your lordship has already, my lord, considering what should be done.
We are considering.
Yes,
We have not considered.
I have said considering.
So let us keep it on another day and consider it afresh. All right. Because we want to get that, what is the principle with regard to compassionate appointment
My lord,
in change of policy?
my lord, in change of policy, when my lord,
We don't want your submission
books.
across the
Yes,
bar.
yes, 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 yes.
Please.
My lord, I will not.
Your
Yes, yes. I will
authorities
be,
are covered.
producing the judgments. I
It is perhaps at the date of consideration of the application.
yes,
The policy which
the
is-
law which was prevailing on that date.
which date?
No.
Law which was prevailing on which date?
My lord, on the date,
Date of
on the date of death.
no
Date of
wrong.
making application.
I say,
Wrong.
just my lord, 1 second.
On the date of
On the date.
application.
This application was
That
subject.
is Ravindran's judgment.
My lord, I am saying,
Bank something.
There are two judgments, the date of consideration
There was
and the
Consideration.
date of consideration.
If there is a change of policy on the date of
Not date of
consideration,
consideration.
that because it's not a vested right.
Yes. This is the
It's a benefit conferred.
date of
So
consideration.
you have no right or a vested right which is being amended. And therefore it will continue whatever is available on the day on which you are getting it.
But that was, my lord, in the date of consideration. In the case of that servition matter, there is
Junior Millard has got the judgment. This
Mhm.
is Miller 2022, 2022, volume 2, SCC 157. paragraph-
Rajkumar something versus State Bank of India.
State of Madhya Pradesh and
Oh.
others versus
Ashish.
Ashish
That's a different.
Asti.
Asti. This
Yes.
is 2022. Now, Miller, this is paragraph. Miller, paragraph 5.
22.
Paragraph 5.
Yes, so read out na bhai.
Millard, as per the settled proposition of law laid down by this court for appointment on compassionate ground, the policy prevalent on the date of death
Date
of
of
the
death.
deceased employee only is required to be considered and not the subsequent policy.
No, this
Millard, this is the paragraph 5.
No, but there is judgment. I have got judgment that on the date of consideration, the policy which will prevail. The date of consideration. It is 18. Without the আমরা out হচ্ছে। 2022 5.
This is
রাহুল দিয়েছে। On the date of
আরো থাকবে। এই যে জিনিসটা দিস ইজ হাউ দি কনফিডেন্স অফ দ্য জুনিয়র সংবিধানে ব্যক্ত করছে। এই তুই এটা রাখছো, তুই ওকে এটা লিখে রাখো।
You bring out there are two decisions. Your live law subscription is needed for going into the 2023 decision is there.
Lord,
We'll
I will-
examine that from that angle also, because these are compassionate appointments. So the schemes and the amendments have to be seen in that light too.
If your lordship wants to address, seek my address on the issue, my lordship will kindly tell me that so that I can come prepared. Formulate the issue
You come prepared.
for on the particular issue, my lord, that compassionate appointment.
Yes. We are contemplating this, that on the angle of your compassionate appointment being made by referring to an amendment which took place in 2020 and was not existing when the partner had died, nor was it existing when your
Order was passed.
application was considered, whether this amendment should apply to you. That is the question. And if the retrospectivity angle is seen, Mr. You understand the problem with that. If otherwise we were with you, sir. Mr. Agarwal, we were with you. If that amendment of 2024 had not come into being, if we are holding that compassionate appointment must be seen as a concession to the entire family, then he also has a right.
Let him also become, my lord. I will make submission on the other day, because even if he is considered, he is out of frame, my lord. Because it comes from the compassion, whether he was dependent, there is one line that
Only
he would
he
have to be dependent on the deceased. So he was not dependent on the deceased. He died even one of the.
So please formulate those
My
points.
lord, that's why, my lord, if your lordship formulates the point, then I can complete. Otherwise, if your lordship will, then I shall formulate the point.
Please formulate the
My
point and address us.
My lord, I shall
The question of an assistance inter se. All right, not to lay down a wrong law.
No.
A person may benefit out of it, may not.
Today I am
benefit out
benefited,
of it.
tomorrow I may not be.
But our purpose is not to pass judgments in a manner which will cause embarrassment in future. Right?
Although that is a. So your
When
lordship.
should we keep it?
Next week, any day?
Not next week. Next
But on that further,
week.
then after 27th, any day, my lord, because
All right, we are adjourning this for 3 weeks.
3 weeks.
Adjourn 3 weeks. Let it appear in the monthly list of
I'm grateful.
July.
Monthly.
In the meantime, in July, 3 weeks, we are not giving in the monthly list, so it will come up on
3
that
weeks.
date. Mr. Bhattacharya, please.
Yes,
go into
yes,
that
I
area.
will. I will. Milord, when your lordship indicated that, I will.
Yes, next.
Apply, my lord.
No, 3 weeks, adjourn 3 weeks.